For school, I'm researching the landmark case, the NAACP versus Alabama. I thought I would go a little further than the internet and interview my neighbors who conveniently know a lot about this case. This is the Jacobs family. Mr. Jacobs' mom was my age when the case came out. The family has always been a part of the NAACP. They told me a lot about the case.
In 1958, the Supreme Court formally recognized the freedom of association as a right protected by the First Amendment. Its victory overturned an Alabama court ruling that had restrained the NAACP from operating in the state and led to its eventual return to Alabama in 1964.
It came about from a 1956 lawsuit against the NAACP by Alabama Attorney General John M. Patterson, who claimed that the organization had harmed citizens of Alabama by promoting the Montgomery bus boycott and several other things.
He also believed that the resulting negative publicity that accompanied these events in the national media had damaged the state's reputation.
Patterson also claimed that they were illegal because the NAACP had failed to meet the basic qualifications for doing business in the state. That's because Alabama law required that an out-of-state company wishing to do business in Alabama had to file a copy of its corporate character with state officials, establish a place of business, and designate an agent to act its behalf. The judge who heard the case ordered the NAACP to immediately cease its operations in the state, pending a hearing to determine whether or not it was truly exempt from the requirements of the law. He ordered the NAACP to produce a number of records relative to its operations in Alabama, including the names and addresses of its members. The NAACP's initial refusal to turn over any records left the group in contempt of court with a fine of $10,000. The judge offered to reduce or even suspend the fine if the records were relinquished within 5 days, but stated that he would increase the fine to $100,000 if the group did not comply. The NAACP did produce many of the requested records within 5 days, but refused to turn over its membership lists.
In doing so, it became subject not only to a high fine, but also to another Alabama law that basically halted all legal proceedings, including the hearing regarding the NAACP's activities in the state until the contempt order was discharged.
After the Alabama Supreme Court twice refused to review the lower court decision, the U.S. Supreme Court took the case, handing down its rulings on July 30th, 1958. Later, I asked some other neighbors who conveniently knew a lot about the case to tell me about the ruling.
John Marshall Hardin II declared this court has recognized the vital relationship between freedom to associate and privacy in one's associations.
He also said that the organization proved that making known its members in the past exposed them to economic reprisal, loss of employment, threat of physical coercion, and other manifestations of physical hostility.
With those outcomes expected to recur, the court believed that forcing the NAACP to comply with the state's court ruling would likely hinder it and its members from organizing and advocating with their beliefs.
The court added that compelling the disclosure of the NAACP's membership also encouraged some individuals to leave the organization and discourage others from joining.
In one sense, the court's ruling in this case was very narrow.
The ruling technically only overturned the contempt order and the $100,000 fine against the NAACP. 5 more years and several more appeals to the Supreme Court were necessary to determine the legality of the NAACP's operations in Alabama. In a broader sense, however, the freedom of association announced by the court in this case became a critical component in the NAACP's efforts to end racial discrimination in Alabama.